You want to know what a day in the life of a defense attorney is like? Well, let me tell you about my yesterday. Chad Daybell, he gets a new outfit, and we find out that he actually smiles. The Gilgo Beach suspect is stacking up the bodies. Wait until you hear about the new details. Now, a YouTuber has been arrested. Should we all be concerned? We have some Parents of the Year contenders, and not in a good way. Sara Boone, exactly how many attorneys will the judge give her? Will it be 9? And then our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember to listen to us on any of your favorite podcasting apps. All right, let's go ahead and get to the docket. Now, I wasn't here yesterday, all right? And I'm going to explain why. Well, let's get to the docket. Let's open the record for June 7th, 2024. And first on the docket, Colorado man is sentenced to 448 years in prison for his human trafficking case. All right, ladies and gentlemen, I have shared with you the ups of my law practice, and occasionally I give you the downs, all right? And I've told you, oftentimes I get some of the very tough cases when nobody else will take them and somebody wants to go to trial. They call me, all right? And sometimes that results in big sentences when you lose and you do what you can. As you may recall, I was out for a month in March because I was doing a trial. Well, yesterday we had the sentencing. And let me tell you, you know it's not going to be good when the jurors show up. We had 6 of the 12 jurors appear at a sentencing. Whenever that happens, you know it's not going to be good. Anyway, yesterday was a fait accompli. I had represented a client, and let me show you this. It was on all the major news channels. Anyway, that's right, 448 years. I'm not sure it's the biggest one if you count life sentences or multiple life sentences plus a couple hundred years, but this is getting up there. So that's right, 448 years for my client in prison for human trafficking. Don't you want to hire me as your attorney? Apparently, I'm the best. But you know what? We are always able to turn a negative into a positive. 448 years, guess what? We're number one. We're number one. We have the longest sentence for a human trafficking case in Colorado, if not the United States. That's right, Mr. Hawkins. And let's just be clear, I'm not talking about anything that was not said in open court, totally not speaking out of school in any way, but Mr. Hawkins, who, nice enough guy, he was sentenced to 448 years in prison yesterday for convictions of human trafficking of both adults and a juvenile. And like I said, could be one of the longest sentencing in Colorado. Now, a jury had found him guilty back in March on more than a dozen counts, 5 of which were human trafficking charges. And this was really 3 separate cases that were all combined. Our position was they shouldn't have been joined. It was very prejudicial. And anyway, the judge didn't agree with us, and we went to trial on all of them, hence the reason it took 3 weeks. Anyway, there were 7 victims in this particular case, and they all came and testified in court. Prosecutors did note that Mr. Hawkins was offered a 40-year deal early on, but he did not accept it. And one of the reasons that issue came up was because Mr. Hawkins was sentenced as a habitual criminal offender, which means he is sentenced to 4 times the maximum presumptive range because of the number of felony convictions he has. So let's say, for example, let's just say whatever the high end of the sentence would be, you multiply that by 4, and you have all those counts. They can all be consecutive. And what the judge did in this particular case was say, all the victims, I'm going to make those habitual counts concurrent, and then the other counts, each victim consecutive, hence the 448. Now, the DA said, hey, the 40 years is what was offered to not have to put everyone through the trial. And our position was, well, Judge, if 40 years was appropriate when this case started, it should have been appropriate now. And just because he exercised his right to a trial doesn't mean that he needs a 1,020% increase in his sentence because he exercised his constitutional right. People are allowed to do that. And needless to say, the prosecution also stressed that between 1997 and 2023, Mr. Hawkins had been arrested, cited, or detained for investigations, wait for it, 57 different times in 22 different matters. So let's just say, ladies and gentlemen, certainly when you represent somebody, you do not necessarily condone what they do, but you represent them and make sure their constitutional rights are protected. Every person is entitled to their day in court, and whether they accept deals, that is their decision. And then ultimately, sometimes you got to go take those cases to trial. Sometimes it's painful. And sometimes you think, wow, that 40 years probably looks pretty good right about now, doesn't it? Anyway, so just remember, not only do you watch an attorney on YouTube that actually does cases, that's right, he tries the tough cases as well. And sometimes the cases that nobody thinks are ever going to win, well, sometimes you don't. And then you get big old sentences. So, we're number one. Next on the docket, Mr. Pryor has filed an appeal to ask the Idaho Supreme Court to look at the verdict and the proceedings where the death penalty was imposed for Chad Daybell. Now, what we were also able to determine was, look at this. Chad, who's always made every court appearance in his little white shirt with a tie with no expression, well, now he looks like this in orange. He doesn't shave. And look, he even smiles for the camera. Amazing. Well, get used to it, Chad, because that's where you will be spending the rest of your life until the state kills you. More than likely, you'll die of natural causes before then, but you get the drift. Anyway, so after every trial, everyone has a right to an appeal. And if you cannot afford an attorney, guess what? You're entitled to court-appointed counsel to represent you at that next level. So the judge has granted a motion to proceed in formis pauperis, which means that Chad Daybell will get a court-appointed attorney and all the transcripts and everything paid for at no expense to him. He will receive super due process because it is a death penalty case. And you also file a notice of appeal, like I'll be filing, right? And a notice of appeal is kind of put the other side on notice. It's really perfunctory because the attorney filling out the notice of appeal may think there are particular issues of some substance where the appellate attorney is like, yeah, no, that's not a really good issue. Or I prefer this issue better, something along those lines. But you have to give them some questions or some guidance as to what's taking place. So what did the attorney, Mr. Pryor, ask the appellate courts to consider first? Did the court err in the granting of Daybell's motion to dismiss the grand jury indictment? Did the court err in ruling Dr. Davidson's report and testimony would be inadmissible in the case? And did the court err in allowing the prosecution to amend their indictment after they arrested? I think that's a good one. Did the court err in denying the defense motion to dismiss the case? Probably not. Did the court err in providing to the jury the most current jury instruction of reasonable doubt at the guilt stage? And did the court err in providing the jury the most current instruction of a reasonable doubt at the sentencing phase? Now, Mr. Pryor also filed a separate motion requesting, obviously, that he appoint counsel and that it be at state expense, which was obviously granted. So we'll see how this plays out over the next several years. My guess, the first salvo on a notice or the appellate brief filed by the petitioner, Chad Daybell, will probably be filed in about 1.5 to 2 years. All the transcripts will have to be prepared. The attorney will have to go through the record. They don't necessarily go through all of the discovery in the case because it only matters what's on the record, the cold, hard record, to see if errors were made. Remember, everybody's entitled to an appeal, but just because you lost doesn't mean you're going to win. It just simply means it is a review to see if an legal error was made that was so significant that it resulted in an unfair trial. About 2% of all cases that go up on appeal get back to the trial court for a new trial. So remember that, 2%. Next, new developments in the Gilgo Beach murder. This dude is stacking up bodies. That's right, Rex Heuermann. 2 new victims. Apparently there's some DNA evidence, and came as a result of the search at their Long Island home. So Rex Heuermann was indicted by a grand jury yesterday for the murder of 20-year-old Jessica Taylor back in 2003 and 28-year-old Sandra Costilla back in 1993. Now, police said they were able to use new forensic testing methods to match hairs found on or near the vicinity of both victims to a DNA profile that are likely to match Mr. Heuermann. Now, the new charges came just days after police finished extensive searches of Mr. Heuermann's Massapequa Park home in a wooded area on Long Island tied to the investigation of the string of deaths known as the Gilgo Beach murders. Anyway, prosecutors say they found a planning document. A planning document. How I'm going to plan to do harm to others? Not good fact for the defense. Anyway, this planning document was found in the home where Mr. Heuermann allegedly used to methodically blueprint his killing in a hard drive that was found during the search. Curious, no one had found it thus far, particularly like his ex-wife. Well, apparently in the document, Mr. Heuermann allegedly lays out a set of tasks to complete before, during, and after the killings, including checking the weather, setting up a staging area. It also has a place to note practical lessons for next time. You know, that's really showing some leadership there. Where do we make some mistakes? How can we do better the next time? Anyway, one section is titled Body Prep, which includes guidance to remove the head and hands of the victims, as well as tattoos and marks of torture. Now, Mr. Heuermann also allegedly left a reminder for himself to wash the inside and all cavities of the victims. Another section, Things to Remember, appears to apparently highlight lessons learned from previous killings that should be heeded, according to prosecutors. Now, these entries describe the importance of sleeping properly before the hunt, using thick rope, and limiting noise to increase playtime. In a section titled Post-Event, there were reminders such as change tires, burn gloves, dispose of pics, and have story set. Now, Mr. Heuermann also allegedly listed potential and past dumping sites, as well as the supplies he had at hand. Now, in the section titled Problems, he allegedly listed potential ways he could get caught, including bloodstains, witness identification, and hair and fiber evidence. Apparently, he wasn't careful enough. Investigators also believe the torture happened inside Mr. Heuermann's home, as the document includes concern about how sound travels. Now, with Mr. Heuermann's family vacationing out of state, apparently then the defendant would have unfettered time and exclusive access to his house, allowing Mr. Heuermann ample time to execute and clean up these crimes, according to prosecutors. Now, the alleged killer pled not guilty to the new indictment, and guess what? He's going to be held without bail. I think he is a danger to the community, ladies and gentlemen. Now, we'll give him the presumption of innocence, but when they find a checklist on how to kill and torture people, and you're accused of that, it's not a good fact. Well, in addition to the hard drive, prosecutors said they found a book in Mr. Heuermann's possession by the retired FBI agent John Douglas, The Case That Haunts Us. They say the planning documents also referenced specific pages in another work by Mr. Douglas, Mindhunter, that alluded to the personality types of serial killers and personality profiles of those who use mutilation and sexual violence. Now, let's talk about the victims. Jessica Taylor vanished in 2003 while she was working as an escort in New York City. Some of her remains were discovered in the Marinville area that particular year, and other remains were found in 2011, near the same road where other Gilgo Beach victims were found. Now, guess what? She had been decapitated, and both of her arms were severed. Moreover, a tattoo on her torso had been severely obliterated by a sharp object. Oh, that's right. That was on the checklist of things to do and found in Mr. Heuermann's house. Not looking good. Now, as you may recall, back in April, the police also spent days searching the property of Mr. Heuermann, where Castillo's body was discovered back in 1993. And Ms. Castillo was from Trinidad and Tobago and then she lived in New York City. Now, forensic examiners found 2 unidentified male and female hairs on her remains, which in February were determined to match Mr. Huerman and an unnamed woman he had been living at the time, according to the court records. Now, those charges involving Castillo, who was killed 30 years ago, indicate the prosecutions believe that Mr. Huerman was killing victims for much longer than they previously thought. You think? Yeah, nobody gets caught on their first dead body as a serial killer, right? This is going to be an interesting trial. Next, a YouTuber's been arrested. Should we be concerned? Probably not. Look at this knucklehead. Suk Min Choi, better known as Alex Choi, faces 10 years in federal prison after he filmed this stupid stunt for his YouTube subscribers. And the FAA has also revoked the helicopter's pilot's license for flying under the altitudes required by law and failing to display the chopper's N number. Now, this video was created as and is deemed to be a hazard to persons and property by operating the helicopter in a manner that was careless and reckless so as to endanger the life and property of another, the complaint alleges. Now, Choi filmed the stunt last year to ring in the 4th of July back in the Mojave Desert. He made the appearance in the L.A. Court appearance, and he has not yet been arraigned. Now, like I said, Mr. Choi is charged with 1 count of causing the placement of an explosive or incendiary device on an aircraft, according to the United States attorney there in California. He was arrested on Wednesday, and he is expected to have an arraignment in the coming weeks. Now, according to the arrest affidavit filed in the complaint back on July 4th, 2023, Choi posted in his video destroying a Lamborghini with fireworks. In the video, Choi presses a fire missile button while 2 women are in the helicopter shooting fireworks at a speeding Lamborghini sports car. Now, police believe the video was shot on the El Mirage dry lake bed in the San Bernardino County area. Now, the statement goes on to describe how investigators discerned that Mr. Choi was the one filming the footage, which was posted on YouTube, but guess what? It's been taken down. Well, after the dangerous incident, the video transitioned to a behind-the-scenes look at how Choi shot the first third of the clip, during which the YouTuber allegedly made various references to himself coordinating the shoot. Specifically, the complaint states that Mr. Choi states in the video that he directed it before pointing to a clip where Mr. Choi thanks a camera company for being a part of my crazy, stupid idea. Now, Mr. Choi has built his program promising viewers the greatest car shenanigans. Well, they may be out of pocket for a little bit. Mr. Choi will be, because he faces up to 10 years in prison. Just a little tip there, Mr. Choi. Don't do stupid things and film it in airplanes. It's bad enough when you do it in cars, but guess what? The FAA don't play. I have seen many a YouTuber that does very routine cases or flying videos where they literally take off and land, and guess what? The FAA contacts them because somebody complains about it. That's the world that we live in. But don't do stupid things. You know better than that. And the pilot, you knew better than that. Next, let's move on to a couple of the Parent of the Year contestants. The parents of a 3-year-old boy have finally been arrested nearly a year after he died of an overdose of cocaine and fentanyl. Meet Parent of the Year number 1, Musa Hawa, 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 and Holly Back. Well, they've been charged with third-degree murder, involuntary manslaughter, with a sundry of other charges, according to the district attorney. The criminal complaint alleges that investigators were called to the scene at the house on July 26 of 2023. They found Hawa performing CPR on the unresponsive child. Officers took over the CPR, noted several crystalline baggies scattered throughout the living room and other medication bottles in a bag on the floor. Needless to say, medical personnel took the boy to the hospital, but he later died. Blood and urine samples from the child found cocaine and fentanyl in the child's system. A hair sample also discovered traces of fentanyl, indicating exposure to the drug prior to the overdose. Investigators, when they searched the house, found empty heroin bags on the floor of the room where officers first encountered the child, along with a shoebox where they found hundreds of small baggies that each contained blue fentanyl meth/heroin bags that were either empty or contained some residue. The detectives also found some text messages between the two adults discussing drug use on the day the child overdosed. According to that complaint and information, Hawa told investigators that his son knew not to touch what his parents called daddy's medicine. Miss Back was given a $1 million bond. At her arraignment, Mr. Hawa is already in jail serving an unrelated drug charge. Are you kidding me? Parents of the year, ladies and gentlemen. Are you kidding me? Daddy's medicine? I'm not exactly sure what they're facing. Whatever it is, it's not enough. Had a friend, an attorney who was representing an individual, very similar situation where the child died because daddy's medicine was out there on the table and the kid put it in his mouth and died. Little toddler. Happens too frequently. Shouldn't happen at all. And those parents should be held accountable. That is reckless behavior. Next on the docket, Sara Boone. Remember the woman that zipped up the boyfriend in the suitcase? Well, she is on attorney number 8, and guess what? She wants attorney number 9. How many attorneys will the judge give her? So like I said, Ms. Boone is accused of killing her boyfriend by zipping him inside of a suitcase. She was back in court with her 8th attorney on Friday, where she told the judge she's still unhappy with her representation. Now, Ms. Boone is charged with second-degree murder for the death of Jorge Torres, while Boone has admitted to zipping Mr. Torres into the suitcase where he was found dead. She has maintained that she did so as part of a game of hide-and-seek that just simply went wrong. So, when Boone appeared at the status hearing this morning with her 8th attorney, Patricia Cashman, Cashman was assigned to replace the list of attorneys that couldn't get along with Miss Boone either. Anyway, Miss Boone called the previous attorney a dud and a buffoon. Apparently, according to the Ms. Boone's statements to the court, everyone constantly blames me why I am now on attorney number 8. I mean, I guess that's kind of reasonable, right? Ms. Boone says, I am not the reason for any of them. Now, Ms. Boone took it upon herself to hand the judge an envelope, which was a 58-page letter, apparently, asking for the judge to intervene because she believes her latest attorney is mistreating her. She wants everyone to be aware what she is going through. It's a matter of ethics and professionalism of how she should be treating Miss Boone. Now, Miss Cashman addressed the judge, saying that she has spent nearly 20 hours with Miss Boone and has accepted collect phone calls from the jail, for which she'll not get reimbursed. And Miss Cashman accused Miss Boone of walking out of their previous 2 meetings after she didn't like hearing the results of the deposition and discovery. Oh my gosh, you mean attorneys are telling your clients what they need to hear, not what they want to hear, and the client doesn't like it, so they can just keep going? Anyway, Ms. Boone told her most recent attorney that apparently from day one of their meeting that her snotty attitude was inappropriate, and I will try very hard to bear with her and her attitude. I feel that her attitude has equaled prejudice, which is not in my favor, especially considering she's going to be representing my life. Well, the court did not let Ms. Cashman off the case yet. For Ms. Boone, that decision will be made, but the court went ahead and set the matter for trial. We'll see. That trial's in October 7th to be exact. But let me just tell you, ladies and gentlemen, if you can't get along with 7, 8 attorneys, guess what? You can't get along with anybody. And the judge should say, I've given you every opportunity. It's not an attorney problem. It's a you problem. And since you are unable to look and reflect upon that, you're going to go to trial on October 7th, and you're going to do it yourself. And although you can say you want an attorney, you don't get one because you can't get along. Anyway, next on the docket, our dumb criminal of the day. A Wisconsin man who rushed the stage at his daughter's high school graduation to keep her from shaking the hand of an administrator was charged today for disorderly conduct. Now, apparently Matthew Eddy disrupted the ceremony at the Baraboo High School moments after his daughter Elsie's name was announced. She collected her diploma and then began shaking hands with everybody on the stage, which is quite customary. Well, in the police interview, Mr. Eddy claimed that he and his daughter had past issues with Rainey Biggs, the person he didn't want his daughter shaking hands with, over some sort of dissatisfaction over an administrative proceeding of some type. Anyway, when all the interviews were done, apparently the father said something to the effect of, you're not going to shake my daughter's effing hand, and push Mr. Biggs away. So now the dad has been charged. Now, I would think that if you didn't like an administrator, she could just not do it. I don't think dad needs to rush up there on the stage. That's kind of dumb. And you would think if you didn't get along with that administrator, you'd be like, yeah, shake your hand and be like, told ya. Anyway, Mr. Eddie, you are a dumb criminal of the day. Thanks for watching. Have a wonderful weekend, and we'll see you next time on Crime Talk. And remember, the Constitution matters.